of the Ninth Circuit of the United States Court of Appeals, and Banc decision, as I mentioned a little bit during my opening remarks today. I would like to introduce our panelists and move on with our panel. Our first panelist, as you've heard numerous times, our first president, David Balabanian. He is a litigator with more than 40 years of experience handling complex, high-stakes commercial litigation, including securities and antitrust cases and takeover litigation. The 2008 edition of Chambers USA, America's Leading Lawyers for Business reported, David Balabanian is a marvelous counselor and impressive trial lawyer who is well respected for his extensive experience and ability to, quote, appeal to judges as well as juries. David has also been listed in all editions of the Best Lawyers in America for over 10 years. In 2006, he was named as the Litigation Attorney of the Year by California Lawyer. I will skip some of course you heard he's the first president of Armenian Bar. He received his education at Harvard College, Oxford University, and Harvard Law School, and is admitted to practice in California, New York, and District of Columbia, as well as before the U.S. Supreme Court and many federal district and circuit courts. But most importantly, when he turned 18, he changed his last name from Balaban back to Balabanian, and that's based on, you know, the story we heard from Wally today. It has to be mentioned, you know. We're also very pleased to have Kate Nahabedian with us. Kate was also worked together with our organization on this, on many matters, but on this particular case as co-amici for the entire amicus curiae. ANC has been a sister organization along with Armenian Bar, and I can't tell you how much time, work, effort, phone conferences, and it's still going on, and we're very appreciative of it. It's a pleasure to work with her. She is the Government Affairs Director for the Armenian National Committee of America, the largest grassroots Armenian American organization with offices in Washington, D.C. and Los Angeles, and over 40 chapters across the country. Prior to joining ANCA, she worked as an attorney litigating complex class actions. In addition, she worked as a policy analyst with the Community Relations Service of the U.S. Department of Justice, which mediates ethnic and racial conflicts. I'm just going to mention her. She graduated magna cum laude with a degree in International Studies from American University and received a JD with focus on international and human rights law from the University of California at Berkeley School of Law. The rest, you have it in your package. You can read. I'd rather move on. I think David wants me to move on. I'm going to hand him the microphone.
Thank you very much, Edwin, and thanks all of you for joining us. Our purpose in this panel is to give you the procedural history, extraordinary procedural history of the Movsesian case, give you our understanding of it and our plans for future action in that case, as well as implications for other steps that the Armenian community can take with the issues that were involved in that case. There's a great deal of misconception about the case. Some things have been said and written about it are simply not correct. That's hardly surprising, given the extremely unusual procedural history of this case and the complexity of some of the issues. To help you master it, we have prepared, or I have prepared, a cheat sheet here that gives you the relevant statute, the procedural history of the case, and key excerpts from the decision, the Banc decision of the Ninth Circuit. In doing so, I don't want you to think that I lack the ability to do a PowerPoint. I could do that. It's just that there's so much information here that I thought it would be better if you had it in hard copy. It's also something you can take with you and refer to in the future as the case proceeds and if you're asked any questions about it. With the case, basically, it requires an interpretation of California Code of Civil Procedure 354.4, which is set forth here in the handout. That section extended the statute of limitations for claims based on insurance policies, quote, purchased or in effect in Europe or Asia between 1875 and 1923. Claims brought by California heirs, and by the Californians, of an Armenian genocide victim. Armenian genocide victim is then defined as, quote, a person of Armenian or other ancestry living in the Ottoman Empire during the period of 1915 to 1923 exclusively, who died, was deported, or escaped to avoid persecution during that period. It's worth noting that the statute as written does not actually require for a membership in the group of Armenian genocide victims that one had been a victim of genocidal conduct. Indeed, it would apply to someone who died in their bed during that period in that place. Indeed, the only provision of the statute which on its face would appear to require any inquiry into the circumstances under which a person died or was adversely affected is the last phrase, which would extend the benefit of the statute to heirs of a person who escaped to avoid persecution during that period. Conceivably, that could require an adjudicating an individual claim inquiry into the circumstances in which that person left the country and whether those circumstances constituted persecution. Can everybody hear me okay? I can go on this way. The procedural history of this case is truly remarkable, really unique in my experience, my very long experience. This case is now nearly 10 years old. It was filed in the U.S. District Court in Los Angeles on behalf of the heirs of persons who held life insurance policies issued by the defendant. It's a follow-on of an earlier case, which you are probably aware, brought against New York Life on behalf of persons situated. In that case, the defendant settled, in part at least, because of the pressure brought to bear in the press and elsewhere with regard to the claims being made. This case, however, was brought against the German insurance company, Victoria Versicherung, AG et al., which did not care very much about adverse publicity in the United States, and proceeded with the obvious support of the Turkish government to resist the claim. In 2007, the district court rejected the defense raised by the insurance company that the whole area covered by the statute was preempted because it bore on the foreign affairs powers of the United States and therefore not proper action for an individual state. Soon thereafter, the Ninth Circuit granted interlocutory review of that ruling. That is itself quite unusual. It is very rare for any circuit, certainly the Ninth Circuit, to agree to hear a legal issue in the middle of the case. And perhaps itself was some indication of concern on the Ninth Circuit's part regarding the ruling below. Nearly 2 years later, in August, a three-judge panel of the Ninth Circuit, by a vote of 2-1, found that the statute was indeed preempted because it did affect area of foreign relations, remitted by the Constitution exclusively to the power of the federal government. It was at that point that the Armenian Bar first became involved, and I was asked, I'm very honored to have been asked, to assist in preparing an amicus brief. Ultimately, we filed such a brief. We were joined in that in that brief by the ANC, the Zorian Institute, and other organizations and interested persons. The points that we made in the brief, principal points were the following. We submitted a detailed written record, which had not previously been before the court, regarding the number and nature of the actions taken by the states and localities in recognizing the Armenian genocide, using that word and expressing concern and support for the Armenian cause with regard to that issue. We pointed out that none of those had ever prompted any action or received any disapprobation by the U.S. government. We also chronicled the lengthy, albeit somewhat uneven history of actions or inaction by the federal government in this area, none of which suggested any policy of the part of the federal government that would prohibit the states from taking action such as reflected in these resolutions or reflected in the statute. We also pointed out that on its face the statute did not create any cause of action for genocide or require any adjudication of genocide. It simply used the term Armenian genocide victim to define a class of persons who would enjoy the benefit of suspension of the statute of limitations not on genocide claims, but on contract claims based on written policies of insurance with a German insurance company, and therefore could not and did not, in fact, constitute a challenge to or attack upon a foreign government or require any action on the part of California courts in adjudicating the rightfulness or wrongfulness of any action by a foreign government. About a year later, we received, relatively soon thereafter, we received a ruling from the three-judge panel, which had ruled 2-1 against us, that reversing itself. That is something really unique in my experience, to have a court reverse itself by single vote without a rehearing. They granted the rehearing and summarily reversed themselves, in an opinion which largely recited the facts that had been contained in our amicus brief, pointing out many times in which genocide had been recognized by various states and localities, and also noting that the federal government had never stated a clear policy against such recognition. Indeed, on numerous occasions, different branches of the government have affirmatively supported the cause of recognition. The case then slumbered for an extended period, during which time the defendants moved, as was their right, for yet a further hearing. I don't know how many of you do appellate work, but rehearings in the Ninth Circuit or in any circuit are themselves rare. Indeed, I've managed practice law for 43 years out without ever encountering one. So we'd already had one rehearing by the three-judge panel, which reversed itself. And then in November of 2011, the Ninth Circuit, to our surprise, granted a rehearing en banc. Now, en banc hearings in the Ninth Circuit are not really en banc. They do not involve the entire circuit. The circuit is so large and so geographically dispersed that it's not practical to bring together all the judges from Guam and East Snowshoe, Idaho, and wherever they are, to one place. And so they sit in a panel of 11, which is drawn randomly from the entire composition of the court. It amounts to about half of the court. There was another round of briefing, and then a hearing. In preparation for the hearing, we were able to provide support to counsel for the parties themselves. We were, of course, not a party to the case, but we did help in preparing them for the argument. In particular, we spent a good deal of time in moot courting with one of the counsel, Mark Gargos, to ensure that we covered all the issues that might come up at the hearing. And in that connection, I enjoyed the support of one of my partners, David Simmons, who's a former member of the U.S. Solicitor General's argument department, and had argued 12 cases in the U.S. Supreme Court. The hearing took place in San Francisco. There was a great deal of interest expressed on the part of the court as to what, if any, policy the United States actually had on the issue, whether they took a position, if this statute was going to be found unconstitutional on the ground that it conflicted with federal policy, and perhaps wanted to find out whether there was, in fact, a federal policy with which it was in conflict. And we left the hearing thinking there was some chance that the court might invite the U.S. to state its position, which might in itself have been useful, very helpful. It did not do so, however. Instead, in February of this year, it ruled unanimously that the statute was preempted not because it actually conflicted with any federal policy, but rather because it affected a field, namely U.S. foreign relations, which was uniquely within the province of the federal government. This is called field preemption. So I'm going to take just a minute to lead you through some of the key excerpts from the decision, because I think they're very helpful in understanding what actually happened here, where we now find ourselves. As you can see from the quotations here, the court's basic premise was that even in the absence of any express federal policy, a state law may still be preempted if it intrudes into the field of foreign affairs. And this is field preemption. The leading case in that area dates from the Cold War. It's a case in which the U.S. Supreme Court found preempted an Oregon statute dealing with inheritance by citizens of Soviet republics. And even though inheritance is quintessentially a state matter. There's no federal policy on inheritance. Nonetheless, the Supreme Court in that case, the Thornton case, found that an attempt by any state to take action in an area which could require them to judge the actions of a foreign sovereign intruded into that field. The court then proceeded to perform a twofold analysis to determine whether there had been field preemption. First, did the statute concern an area of traditional state responsibility? And although the area of insurance regulation would seem on its face to be an area of unique state responsibility, the court found that the real purpose of the statute, both in the legislative history and in its language, was to provide a friendly forum for those who had suffered from certain foreign events. And that this intruded into federal jurisdiction, citing two Ninth Circuit cases. One, the Garamendi case, which the Ninth Circuit had found unconstitutional, a statute that required insurers in California to identify policies written that might have been owned by Holocaust victims, and the von Sayer case, which dealt with looting from persons affected by the Holocaust, both of which had been struck down by the Ninth Circuit on grounds of preemption. So as to the first prong of the analysis, the court said that although the statute appeared on its face to be an insurance regulatory matter, it really did not apply across the board to any insurance issue, but was focused exclusively on providing redress for individuals who were, in its view, victims of a foreign genocide, even though, as I say, the statute does not on its face require any determination of genocidal activity. This then, the court then turned to the second prong of field preemption, and that is whether the statute intruded upon an area of the federal government's foreign affairs power. In this case, giving the statute, I think, a broader reading than it would bear, found that the statute establishes a particular foreign policy for California, one that decries the actions of the Ottoman Empire and seeks to provide redress for Armenian genocide victims by subjecting foreign insurance companies to lawsuits in California. The court noted, the point that I made earlier, that there was one circumstance in which the statute could, as applied, require individual inquiry into the circumstances under which a particular individual had been affected, and that is the person, whether or not a person had fled to avoid persecution. And on balance concluded that the statute would embroil state courts in determining whether or not a property right should arise based on circumstances that could be characterized as genocide. The court was undoubtedly influenced in determining that the statute affects U.S. foreign relations by positions taken by the government of Turkey. The handling of that was really rather interesting. Although the Turkish government had filed amicus briefs with the court on the subject, the court did not reference them. Rather, the court relied on press reports regarding the reaction of the Turkish government to the action of the French government, which had just taken place at that very time regarding the passage of the genocide bill, and noted that this adverse reaction in Turkey itself tended to confirm that the issue did have foreign policy implications. And the court also noted an article in the New York Times which had specifically commented on the fact that President Obama had conspicuously avoided using the word genocide in certain remarks. So it's clear that one of the factors that the court took in determining that the issue fell within the area of foreign relations was the reaction of the Turkish government, which is not to say that the court concluded that the Turkish government's view should prevail, but rather that the fact that the Turkish government felt strongly about it was a factor that should be taken into account in determining whether this affected the foreign relations. I can't help mentioning that in a recent hearing on the Arizona Immigration Act, which we'll be talking about in a moment, in response to a comment by the Solicitor General that the government of Mexico is very unhappy about the Arizona law, Justice Scalia said, so we are going to interpret our laws and to make foreign governments happy. A point that we'll be making in our cert petition. Finally, and there's more here. I do encourage you to read it. I don't want to take your time reading it all, but the opinion doesn't leave much doubt as to its ground, and therefore you can read it all and see exactly where they went. But finally, and I think of some considerable significance going forward, is the last part, the last entry on this sheet, and that says, we do not and do not offer any opinion about California's ability to express support for Armenians by, for example, declaring a commemorative day. What does that mean? And isn't there some tension between saying that California can pass resolutions that commemorate these events, that characterize them in one way or another, without intruding upon federal foreign powers? And isn't that just as likely to upset a foreign government as the statute itself? As with most judicial decisions that are not entirely clear, we would expect the tension between those two statements to be clarified in the course of further litigation. We'll be talking about that as we move forward. Well, I'm sorry to take so long, but I thought it useful if you understand exactly what we're dealing with, because there's a lot of misunderstanding as to exactly what's happened. I think now we're going to give you a sort of a lawyer's view. I mean, forgive us, this is lawyer stuff and the lawyer's audience, so we're going to talk like lawyers for a few minutes about what this case really means. What is the broadest interpretation that could be placed on it, and then what is the narrowest? And I'm going to turn to Kate and ask her to give the broad view, and then I'll offer the narrow.
Is it on? Okay. So first I want to thank the Armenian Bar Association for inviting me here to present. It's been a pleasure to work with them on this amicus brief. It's been going on for several years. And I wanted to talk, there were several other parties who also joined, not on our brief, but also filed amicus briefs. In particular, on this last stage, on the Banc stage, the Attorney Generals of California, Hawaii, Nevada, Massachusetts, and Rhode Island all joined on one brief. Yes, Rhode Island. And that's something the ANCA worked hard at, reaching out to all these different parties to alert them of this case and their interest in it. In addition, the Earth Rights International and the Center for Constitutional Rights, they filed amicus briefs, and Congressman Schiff, Congresswoman Jackie Spear, Congresswoman Eshu, and Congressman Royce, along with Assembly Speaker Perez, Majority Leader Calderon, Senator De Leon, Simitian, Assembly members Achajian, Gatto, and Portantino all joined on another amicus brief on the interests of the California legislature. And other parties that joined the Armenian Bar and the ANCA on their brief were the Jewish Alliance for Law and Social Justice and the Genocide Education Project. So there were a lot of parties interested in this case. It's not just a concern for Armenian Americans, because this ruling has such far-reaching implications on states' rights issues and property issues. And I also wanted to emphasize that the German insurance companies here, the defendants, they are not claiming that they did not sell these insurance policies, and they are also not claiming that they paid out on these policies. That's not been a defense that they've used. What they are arguing is that the 4 years of statute of limitations is what should apply. That the Armenian orphans that were in the desert trying to survive, that they should have only had 4 years to file for these claims. And they're being represented by Mayor Brown's LA office. So I just wanted to also emphasize that that's their defense, and unfortunately, the Ninth Circuit has agreed with them at this point. But on the broader interpretation of this ruling, this is not an interpretation that we believe is proper, but I just wanted to provide it to you, that because we are facing Turkish groups that are very well funded and have been bringing lawsuits left and right against the University of Minnesota, for instance, that we should be ready for challenges based on this ruling if it isn't overturned. And as David explained, the court analyzed and said that because this wasn't, if it's not a traditional state responsibility, that you should look into the foreign affairs implications. And what a court, when determining whether it is a state responsibility, they don't look at the 10th Amendment. There was no discussion about the 10th Amendment and how all the rights that aren't limited in the Constitution are states' rights. No, what you're supposed to do is look at the real purpose of the statute. And that means you have to analyze the motivations of the legislators. So even though this is a quintessential state function, regulating insurance, determining statute of limitations, contracts issues, everyone understands this is a state issue, but they went into the minds of the legislators and said, no, well, what they're really trying to do, the real purpose of this is to help Armenian genocide victims. And once you do that, then they determine that if it's a foreign affairs matter, not because you're actually trying to provide property rights for an issue that happened abroad. No, it was a foreign affairs issue according to this court because California was supposedly promulgating a political view on a foreign policy matter. So that's also interesting that they didn't say that this is a foreign policy matter because these are property rights that happened abroad. No, it's a foreign policy matter because of the term Armenian genocide is so upsetting to Turkey. And so if you use that analysis broadly, when it comes to the commemorations, this is something we might face, even though that they had that footnote in the decision saying we're not ruling on commemoratives here. But if you're using that analysis, if a state legislature passes a commemoration, what's the real purpose? Is it a traditional state responsibility to comment on foreign affairs? Turkish groups might say, no, that's actually not a state function. They shouldn't be commenting on foreign affairs. Does this upset Turkey? That's the other analysis. Commemoratives do upset Turkey, and actually there are instances where the Turkish government has opposed state legislation or resolutions. But interestingly enough, on this particular statute, this California statute that extends the statute of limitations, there wasn't any evidence brought to show that the Turkish government actually opposed the resolution at the time. And when it comes to the monuments, again, on state property, what's the purpose here? What's the real purpose? Because for instance, the Montebello Monument actually is critical of the Turkish government. It isn't just stating, we commemorate the Armenian genocide. They condemn the Turkish government on the plaque on the monument. And from what I understand, maybe the Turkish government did oppose the erecting of that monument. There is evidence of that. And when it comes to education, there's, for instance, California, Illinois, and Rhode Island all have statutes mandating of the Armenian genocide. And maybe people will argue, well, what's the real purpose of that statute? Yes, education is a quintessential function of state governments, but the real purpose is, they could argue, is to condemn Turkey, and it upsets Turkey, so we should strike it down.
I don't feel that we face any real threat. I'm not sure we'll have litigation, but I would expect to prevail in any litigation that seeks to restrict our ability to continue campaign, to express our views and get them recognized in the state legislatures and elsewhere. Actually, we did in San Francisco, of course, have litigation over the commemorative plaque on the Mount Davidson cross, challenged by Turkey's groups on the ground that it violated the lease conditions under which the cross was acquired by the Armenian organizations. We were able to prevail on an anti-SLAPP motion, California lawyers will know that, in which we not only got the case dismissed, but got an order requiring an injunction against any further litigation by the Turks on that issue, since we were in a protected area of protected free speech. The reason I say that is that I give this case a rather narrow reading. I think that focusing on the language of the case that talks about providing relief, avenues of redress, genocide victims, and what the court was most concerned about, at least measured by the number of times I mentioned it, is the fact that they read the statute as providing a substantive right, admittedly, relief from the statute of limitations, a property right, that would require for its application California courts to adjudicate whether somebody was or was not a victim of Armenian of genocide, and that was an improper intrusion by a state into the foreign policy. I don't think the statute said that. We argued that it did not, that the reference to Armenian genocide was simply a description of the class of persons benefited by the statute and did not require any actual proof of genocide or impact on the policy holders. But the court didn't accept that and treated the statute as if it did in fact create a property right for genocide victims, and that is not a proper role for the state. I don't think that California ever intended to do that. I don't think that the determination that a state by itself cannot create such a property right was an issue that was properly presented by the case. And that being said, I don't think that the court's ruling ultimately affects the efforts that have been made, and I think should continue to be made, to secure recognition of the historic truth of what happened to our people during these terrible years. So the bottom line to me is that we continue our effort. We are going to do our best to secure review in the U.S. Supreme Court. Always a challenge. We are assisted, I think, here by the recent rulings in the 8th Circuit that Kate's going to talk about. We are waiting with great interest the ruling of the Supreme Court in the Arizona immigration cases, where it appears that the court is maybe poised to map out a broad area in which states can take action that do have adverse effects on other governments, and indeed that may, at least indirectly, affect areas that have traditionally been thought to be uniquely within the province of the federal government. So we're going to watch that case with great interest. We are working closely with counsel for the plaintiffs. We have bi-weekly conference calls with Kate and all the people involved. We are enjoying the support of a clinic at USC, students who've been canvassing all of the various state laws that do themselves have foreign policy or foreign effect implications, the resolutions condemning actions of foreign countries, requiring divestment of investments in foreign countries, prohibiting companies from doing business within the states or with localities if they're doing business in a country, a foreign country that is engaged in human rights or other violations. We have a quite impressive appendix already of these matters, all of which have been upheld, not all of which, many of which have been upheld, and certainly not been challenged on grounds of field preemption. So we expect to be able to make a strong showing in the amicus briefs that we will be filing in support of the plaintiffs. But we are also supporting the plaintiffs because in the end it is the briefs filed by the parties themselves that will receive the greatest attention by the court. Why don't we take a moment at least to talk about the 8th Circuit decision, because I think that's the most recent, in many ways, the most relevant legal development. Kate?
So the 8th Circuit decision, this was a lawsuit brought by the Turkish Coalition of America against the University of Minnesota. The University of Minnesota has a genocide and Holocaust studies department, and on their website they had discouraged students from using the materials on the Turkish Coalition of America's website and other Holocaust and Armenian genocide denial websites. And they had told students that this is what they have on these websites is a mix of fiction and fact, and they said they actually instructed students, do not use this material in any of your papers. And the Turkish Coalition of America came up with a novel claim of First Amendment rights violation and also defamation. They claimed that their First Amendment rights were being trampled on because this was a state institution that was supposedly stigmatizing their position and preventing them from getting their message out to other people, and for other people, they weren't able to receive this information. And the court threw out the case on a motion to dismiss. The district court did, and then the 8th Circuit affirmed it. And they said that this is not a First Amendment claim, first of all, because students were still able to access that information. The University of Minnesota did not block the Turkish Coalition of America's website. people could still access it. And on the defamation charge, this is very interesting. They said, well, on the Turkish Coalition of America's website, they do deny that it was a genocide. So when the University of Minnesota says that the Turkish Coalition of America denies the Armenian genocide, well, that's true. So you can't claim that you've been defamed because that's a true statement. And then they also found that when genocide scholars use the term, they deny the genocide, it's also, it's a term of art to say that these organizations are relying on sources that it's a judgment on the credibility of the sources used for these assertions. So that's an opinion, and opinions are not, you can't bring defamation based on opinion. It has to be a fact that can be proved false. So, and what was also interesting in this case is that they referred, it wasn't a big part of the case, but they did, they referred to the Armenian genocide as the Armenian genocide. It wasn't, they didn't put it in quotes. They didn't say, well, some people say it's a genocide, some people say it's not. They just referred to it as a matter of fact. And it's interesting because you have here the Ninth Circuit saying that this term is so charged that states, when they use it, they risk their laws being struck down. But then you have this other Eighth Circuit court using the term freely. But they are different matters because the Ninth Circuit, you're dealing with actually a state law that's been enacted and determining whether that state law is encroaching on the foreign affairs powers of the federal government. But in the Eighth Circuit case, you're not judging a state law at all. You're just judging a claim for defamation or First Amendment violation. So they're a little bit different, but it's interesting how they treated it.
We got started a little late, and I don't want to run into the next panel, so we're going to cut this short. We will be available to answer individual questions that you may have. Obviously, this is very much an ongoing matter, and there will be further dispatches over the next few weeks and months. But to sum it all up, I think, at least from my perspective, the Ninth Circuit determined that California could not do something that I don't think it ever did. And I do not read the Ninth Circuit decision as in any way impairing our ability to continue the efforts that we have made to secure recognition at every level for the historic truth of the experience of our community. And I would encourage everybody to maintain and redouble their efforts in that regard in the hope that we may at some point find opportunities to secure relief and benefits to which we are entitled of those terrible experiences. I want to thank you all. I want to thank the Armenian Bar Association for allowing me and my firm to be part of this activity. It's been a great privilege, a great honor for me, and I want to promise you that we will continue to do our best to protect the interests of our community.
Thank you, David. Do you have any closing remarks or anything you want to say? Or?
Is there time for questions?
Questions probably is best private, but if you want to mention anything that you wanted to mention about the legislative efforts you're making, just a couple of minutes.
Yeah, I just wanted to also, we were going to talk about the Obama administration's position. I think that's important to say that throughout this process, they've been silent. And that's the reason why the Turkish government had to file their own amicus brief. What's traditional in a situation like this is for the foreign government to appeal to the State Department to protect their interests. That's the body that you would normally go to. And the fact that the State Department hasn't filed any papers at this point shows just how much they're struggling with this issue. And what we have is, and the ANCA, along with the Armenian Bar, we met with the legal advisor, Harold Coe, recently at the State Department to talk about this issue, and they don't have a position on it. And we explained to them that if they allow this decision to stand, which is pretty much the federal court's telling us that states don't have a role in this, that we're going to start knocking on their door and saying, well, this means that this has been squarely put on your front doorstep, and you're going to have to work to help us negotiate an agreement to resolve these claims, because that's what the State Department did actually with the Holocaust insurance claims. They created a whole mechanism and brought all the insurance companies and foreign governments and provided a mechanism to resolve these claims. And that's why this case is so different from all the Holocaust cases that were struck down by the Supreme Court and other circuits, because the federal government had actually occupied the space. They were working to resolve these claims, and that's why states shouldn't have gotten involved. But in our case, with the Armenian genocide, it is quite different. The federal government has not taken any action, and something that's we possibly could argue and use is the fact that when the House passed the Return of Churches resolution in December of this year, that was actually more analogous to what we're talking about, which is properties, the return of properties, not the use of the term genocide, because the California statute, it didn't need to use the word Armenian genocide. Its real purpose was about providing a mechanism to resolve property rights. And in December of 2011, Congress actually passed a resolution urging the State Department in all their interactions with Turkey to put pressure on them to return church properties, whether they were Armenian, Greek, or Assyrian, but return them, and schools, churches, orphanages. And and Congress does have a place on foreign affairs. It's not just the exclusive power of the executive branch, although we often defer to the executive branch. Here is a federal government institution saying that it is our interest to have these properties returned.
Okay, thank you very much. This is great. Both of you get the same plaques I gave the morning group. I won't read the whole, but Kate and David, you're also getting a cluster of 4 trees planted in the shadow of Mount Ararat to help fulfill the promise and potential of Armenia. Thank you for your service to the Armenian nation.